Mom always said I'd get the house. Dad promised the business would be mine if I stayed and helped him. She told us at Thanksgiving everything would be split equally. I have heard these statements thousands of times. I'm Michael Hackard, and for 50 years, handling estate and trust litigation across California, families have come to me convinced that what their parents said in a kitchen conversation or a hospital room should decide how the estate is distributed. Sometimes they're right. More often, they're shocked by what California courts actually consider. And that misunderstanding costs families years of litigation, enormous legal fees, and relationships that never recover. Here's the hard truth. In California, written estate planning documents usually control wills, trusts, amendments, deeds, beneficiary designations. Courts strongly favor written documents over informal conversations, no matter how sincere, how recent, or how many people heard the promise. Why? Because after someone dies, they're no longer here to explain what they meant, clarify what they said, or correct misunderstandings. Courts know that memories change, emotions run high, and people often hear what they want to hear. As a result, judges approach oral promises with caution and skepticism. That means if a will or trust clearly says one thing and your memory says something else, the document will almost always win, even if the outcome feels unfair, even if the promise was repeated many times. That reality devastates families, but informal conversations are not always irrelevant. There are specific situations where what someone said during their lifetime can matter legally. One of those situations involves ambiguous documents. If a will or trust uses unclear language, courts may consider outside evidence to understand what the person meant. For example, if a document leaves property to my children and the person had both biological children and stepchildren they treated the same, conversations can help clarify intent. Ambiguity can be obvious on the face of the document, or it can emerge only when the document is applied to real life. In either case, courts may allow testimony about conversations to resolve the uncertainty. Another situation involves mistakes in documents. In a significant California Supreme Court decision, courts were given the power to reform even unambiguous estate documents if there is clear and convincing evidence that the document does not reflect the person's true intent. This is a high standard. Casual recollections are not enough. Courts require strong, specific proof of what the person actually intended and how the mistake occurred. Then there are oral contracts to make a will. This surprises many families. California law allows enforcement of oral promises in limited circumstances. If someone promised to leave property in exchange for services, such as caregiving or business management, that promise may be enforceable even if it was never written down. But these claims are extremely difficult. You must prove there was an actual agreement, not just expressions of gratitude or affection. You must show what you provided, what was promised in return, and that both sides understood it as a binding arrangement. And there is a deadline that catches almost everyone off guard. If you are relying on an oral promise to make a will or trust, you generally have just 1 year from the date of death to act. Miss that deadline, and the claim is gone forever. Before filing a lawsuit, you must also file a creditor's claim in the estate. If no probate is open, you may need to open one yourself, all within that same window. I've seen families lose legitimate claims simply because they waited too long, hoping things would resolve on their own. Informal conversations also matter in undue influence and capacity cases. When someone challenges a will or trust based on manipulation or lack of mental capacity, what the person said during their lifetime becomes relevant evidence, not to change the document's meaning, but to determine whether the document should be valid at all. Courts look closely at consistency. Did the person express the same intentions over time? Specificity matters. I'll take care of you is weak. I will leave you the Oak Street rental if you manage it until I die is stronger. Witnesses matter. Neutral witnesses carry more weight than family members who benefit. Documentation matters. Letters, emails, texts, handwritten notes, and even cards can support claims. Conduct matters. Did the person's actions match their words? Here's what typically happens. Parents talk informally with their children. The conversations are casual. Intentions are expressed. Children interpret them differently. Years later, the parent passes away and the written documents say something else. Some documents are old. Some were changed quietly. Some reflect decisions the parent never explained. Now the family is in court. Each side believes they know what the parent really wanted. The informal conversations become weapons. The litigation becomes emotional and expensive. And even when those conversations are admissible, they rarely provide the clarity families hope for. I worked with a family from San Jose that illustrates this perfectly. A son worked in his father's business for decades after being repeatedly told he would inherit it. He turned down other opportunities and relied on those promises. When his father died, the trust left the business equally to all siblings. The promises were real. The reliance was real. But the written document was clear. The law offered limited options, strict deadlines, and no guarantee of success. Ultimately, the family negotiated a compromise far short of what the son believed was promised. That case reinforces a lesson I've learned over 50 years. The time to fix estate planning misunderstandings is while the person is alive. If you are creating an estate plan, put your intentions in writing. Update documents when circumstances change. Be specific. Communicate clearly. If you are expecting an inheritance, do not rely on oral promises. Encourage proper planning. Document arrangements. Act immediately if problems arise, because what someone said does matter. But understanding what California courts will actually consider matters even more. And knowing that difference can save families from heartbreak that no courtroom can ever fully repair. Hackard Law represents heirs and beneficiaries in estate and trust litigation in the San Francisco Bay Area and throughout California. You can call us today at 916-313-3330. We look forward to hearing from you.